What's up, ladies and gentlemen? It's the Resistance back at you, and it feel like it's been a long time, but life is good. Hey, man, I got those audio recordings for y'all. Got them audio recordings from the pre-trial hearings, and I got the audio recordings from the exact trial. So, what I was going to do is I was going to update y'all on a couple of things. I was going to let y'all know what was going on with the federal case. Federal case is moving right along, ladies and gentlemen. Also, I was going to give y'all a brief view of the response that Scott Roby made to the complaint of the federal case. So here you go, right here. This is from the courts right here, and this is Scott Roby's response to my federal complaint. And just give y'all a brief description. I'm going to tell y'all exactly what's going on with this. Basically, Scott Roby denied all of my allegations, everything that was factual within the video. He kind of like denied all the allegations that I put on him as far as, the violations, the constitutional violations, and, the assault and battery. And I was actually charged with assault and battery on Scott Roby. He's complained about a scratch on his hand, but that never came into fruition. Even though they did produce pictures, it was a little bitch ass cut, and it just wasn't realistic to what they were trying to present in court. So what you're looking at right here is basically his response, general allegations from me, and he admitted that he attempted to arrest me. He admitted that I was in the street. Every little thing in my complaint that was actually true for them, they admitted to, but the parts of him violating my constitutional rights and violating me and, assaulting me and all that, he denied. So they submitted this maybe about 2 weeks ago, week and a half ago, and the courts, they distributed an order. This is by Judge Stearns, United States District Court, District of Massachusetts. This is the judge's orders, and docket text says that Judge Richard G. Stearns, electronic order entered, defendant Scott Roby having answered the complaint, the city of Boston having been dismissed, and the extended time for service of the remaining defendants has expired. The court enters the following pretrial schedule. Initial disclosures required by Federal Rules Civil Procedures 26A1 must be completed by 11/16/2022. Initial disclosures is a requirement under the federal rules that parties make available to each other the following information without first receiving a discovery request: the names, addresses, and telephone numbers of persons likely to have relevant discoverable information, a copy of description of all relevant documents, data compilations, and tangible items in the party's possession, custody, or control, damages computation, and relevant insurance agreements. Okay, so basically what they're asking us to do, both parties, defendant and plaintiff, which is I have to give them the information that I had before the courts actually request discovery, and vice versa. The defense has to produce all the evidence that they have as well. So I'm getting that in process. I actually have a due date of 11/16/2022, which is right around the corner, and I'm working on all that as well, which is really telling, ladies and gentlemen. If you pay attention to number 4 right here, number 4 says any relevant insurance agreements. I know you guys have heard me speak about surety bonds, indemnity bonds. I know you guys heard all that stuff, and kind of funny that in this order, the defense, Scott Roby, has to produce his relevant insurance agreement, which is great. And if they don't, then I'll just move the court for them to do so. Okay, moving on. Motions for leave to amend pleadings and joinder of parties must be filed by 12/16/2022. Without leave of court, the parties are permitted to serve 30 interrogatories, 30 requests for admissions and 30 document requests to be served within the 30 days of the initial disclosures by 12/16/2022. The court expects responses to be made in 30 days unless a request for additional time is granted. A party may not notice more than 2 depositions without leave of court on a showing of good cause. If the parties would like to participate in the court's mediation program, they must notify docket clerk Arnold Pacho with the phone number by 2/2023, February 2nd, 2023. Often the court can enlist volunteer counsel to assist the pro se plaintiff at the mediation. All fact discovery must be completed no later than February 24, 2023. Such summary judgment motions are due by March 24, 2023. Oppositions to any summary judgment motion is due by 4/14/2023, 21 days after the filing of the motion. Reply, if any, by leave of court. So, ladies and gentlemen, this is what's going on here in the federal case, okay? Now, this is what they do. They actually work by their own game plan to try to bombard and intimidate the pro se plaintiff, okay? It looks good. It's moving along, but they use the federal rules and procedures to go against the pro se plaintiff by bombarding. You know, pro se plaintiffs don't have any experience as a federal attorney who's been going to school, went to school for 10 to 12 years. You know what I'm saying? So I got my work cut out for me. But listen, I want to give a shout out to everybody in the chat. I appreciate y'all. Y'all need to share this. We about to come up on the audio recordings of all the pre-trial hearings. And at a later date, we're going to go through trial. I told y'all I was going to get that, y'all. I told y'all I was going to get it. And guess what? It's here. Let's go. Hit the lights. Everybody about to get killed out here. Like it for everybody. That's right. Like it for everybody. It's the resistance, man. So, first up is I got the docket sheet in front of me as well. So I'll be going through the docket sheet. I got about 4 pre-trial audio recordings. But before I do that, just want to run down the list of everybody that's in here. I appreciate y'all. Once again, make sure y'all share this, like, and subscribe. Shout out to Yum. Perfect Sense is free to stay. Rhonda, Grab It Hard. Daniel Garcia, my man. What's going on, bro? David Avila. President Santa. So like I said, we're going to get into this audio recording. And the first one is from October 2nd, 2020. That was the first hearing. And I also have a video of the actual arrest of this case. So we're going to get into this real quick.
Thank you. What's the issue? Commonwealth President John McCullough.
And that's me.
Document number 1087.
Morning, Sheriff.
Good morning, Your Honor.
Good morning, Your Honor. Oh, afternoon.
How are you?
I'm fine. How are you?
Good.
On this matter,
And I wait for you to plead not guilty.
I don't think he's going to be arraigned. I think the Commonwealth is going to dismiss it prior to arraignment.
Huh.
Now, that voice right there was my public defender. They were asking, how was I going to plea? And she said, I don't think he's going to be arraigned. We're asking to dismiss it.
Your Honor, the Commonwealth is willing to dismiss this on 25 hours of community service.
That's the prosecutor, Nicole Gabatino. Let me see if I pronounce her name right, because I was saying Nicole Gabatino, and I think it's pronounced different. And when I come across it, I'm sorry, it's not Gabatino, it's Granatino. Granitino. That's the prosecuting attorney. And she wants to dismiss it on 25 hours of community service. This is back on October 2nd, 2020.
I don't know if the defendant has done any community service.
I understand.
But if so, we would like to know how many hours he completed.
There's an alleged victim here. Have you run that by him?
Yes, Your Honor.
You have. Tell me about that.
So at this time, she has no idea. This is the judge is speaking to the prosecuting attorney. She has no idea who the alleged victim is. I'd be damned. She's rifling through her folders to figure out who's the alleged victim in this case.
No, we didn't talk to victims there. Excuse me 1 moment, Your Honor.
Sure.
She needs a moment.
Oh, Your Honor, I believe the alleged victim is
Police officer.
the police officer,
JVP.
Sergeant Detective Brooks. So we did talk to
I see
the
police
sergeant.
officer Scott Roby in the complaint that I have.
So Detective Brooks, ladies and gentlemen, is actually the supervisor who was last to show up in the video. He was the bald head tall guy.
What happened, Your Honor, was I came in on a duty day. Judge Tynes was sitting, and the Commonwealth moved to dismiss the case on 25 hours of community service. Judge Tynes said, well, you have to see if the defendant will agree to that. So let's get another date to have him come in or to have him by phone. So this case actually, I think on the docket, I'll show that it's, I think the court was closed on the date it was supposed to come back, and now it's 10 seconds. So originally it was probably about 4 months ago that the case came up for arraignment.
And that is my public defender, Joan Curran, that was just speaking.
Sergeant Brooks showed up after.
Yes, he did.
I just want to make sure we're thorough.
No, I completely understand, Your Honor. I think it just could be wrong.
So they're taking their sweet old time trying to figure out what they're going to do at the defendant's expense, which is me. And, this was back in October 2nd, 2020. And all the way from the beginning, I was telling them I wasn't taking a plea deal. So they played the game with me for over 2 years, and they ended up losing.
What do you?
Shout out to Mark Wunderlich.
Not the first arraignment date. Has the
It's a lot of dead spaces, so I'm just fast forwarding it.
Your Honor, because I think that he's filed a complaint with the Boston police and has the incident on film and just.
I'm trying to be thorough. That's all my senses.
I think I spoke with ADA Spring and after.
So to be clear, if you guys aren't following, what the judge wants to make sure is that the plaintiff, the actual so-called victim in this case, wants to make sure that he's aware of the deal that they're trying to give me that I've never accepted from the beginning. So they're actually trying to get in contact with another DA who's in the building, and he'll be down momentarily to give a clarification on what they really want. So y'all guys stand by as it please.
We originally had the first arraignment date, because I see that these are serious charges.
Yeah, well, to me, it's just.
And I
There's an
said,
alleged
is that what
victim.
you're asking
That's the
for?
same question every single time. Does the alleged victim know what we're doing to them?
Yeah.
That's all. Could be a police officer, domestic violence, anybody.
I don't think my client would agree to community service.
Does the alleged victim know what we're doing today? And they speaking about Scott Roby, who got the bitch ass scratch on his hand.
It's my
Oh,
fault.
all right. You're the moving party. What are you looking to do, please?
Your Honor, the incident in this report, the victim is the police officer. Obviously, you know that, Scott Roby. However, the injuries to the police officer is that the defendant grabbed his left hand and scratched his fingernail. So it's not to. Oh, and according to ED Spring, who's assigned to this, Your Honor, he spoke to both Sergeant Brooks and Roby, and Officer Roby. They're both aware what's going on about the 25 hours.
Is Mr. Spring in the building?
Yes, he is, Your Honor. Okay.
Please. All right. I'm not trying to be difficult. I'm just trying to do it correctly. I hope you understand that, okay?
Yes, I do.
Okay. Because what we do makes a difference.
No,
Impacts this gentleman, impacts the officer, so let's do it correctly.
Your Honor, I can say ADA Spring is in 2 right now. There's no further ADA up there.
Say that again, I'm sorry?
ADA Spring is currently in session 2. He's the only ADA up there. ADA Page is going to relieve him so he can come down. From the text.
If you want to null prosecute the case, you're welcome to do that. I mean, that's up to you. But if you want me to dismiss the case, your motion, I have a lot of questions to ask, as you know.
Certainly, Your Honor. ADA Spring should be down momentarily.
And it's just our point, if there's no case there, if there's no basis for it, the 25 hours is a penalty that is, shouldn't be imposed.
That would be up to the DA, they're moving to dismiss it. I mean, I don't know if that's part of the negotiations, I have no idea. Sir, I appreciate your patience, I know you've been here all morning, and,
Okay, Your Honor.
is there an ETA on Mr. Spring, or?
Your Honor, I believe it'll be within literally the next 2 minutes. He's just waiting for ADA Page to enter session 2 so that he can exit.
Pass the baton, so to
Yeah,
speak.
exactly.
So right now we're waiting for ADA Springer. He's the head ADA, the head prosecutor and district attorney, and he's upstairs. He's coming down in a few.
Oh,
I don't think there's a request for bail on,
Mr. Spring, how are you?
All right, Your Honor.
He just walked in.
This is John McCullough matter.
Now I want you guys to pay attention to what this district attorney is basically trying to clarify with the judge and the results that they want. So it's very interesting, and this is a very important piece for me as well. That's supportive for my federal case.
We talked about this a minute ago, your name came up, that you were on top of the case, so to speak, and I wanted, because the colleague was looking to dismiss the case, I just asked the obvious question, people know what we're doing, you're a victim.
So I spoke to, or I reached out rather to Officer Roby and to Sergeant Brooks, who was supervising that night. Sergeant Brooks actually responded to the scene.
So,
Officer Roby did not respond to me, but I had a phone conversation with Officer Brooks. His main concern was he didn't want the case just dismissed outright.
So Officer Roby didn't respond. That was the arresting officer. He didn't respond to the district attorney, but the supervisor did respond after the district attorney reached out. And what's quite funny is that they reached out to ask them what did they want to see done in the case? Now that's kind of funny because once the police officers make the arrest and they show what the charges are, the DA is supposed to move on and push those charges. I don't understand why they had to reach back out to the arresters to ask them what they want done. Obviously, there wasn't anything that was, that showed that I broke the law, committed a crime. So they had to, coerce with each other to figure out what they could put together. So the supervisor reached out to the DA and he told them that they just didn't want to see the case go away.
But I think everybody acknowledges that there's mostly a lack of record. And I think that the 24 hours of community service is a good go-between between what the police don't want to see happen, which just this is dismissed and forgotten, and involves the defendant taking some responsibility that doesn't involve necessarily a mark record. So I told Sergeant Brooks that we would come up with a resolution. I suggested community service. I didn't tell him that was definitely going to be it, but I did float that by him. I think his big concern is that there's just some accountability and that there was some acknowledgement that what happened wrong.
Okay,
So in Sergeant Brooks' words, what he wanted to see was some accountability and some acknowledgement on my part, the defendant of this case.
Attorney Karen?
Yeah, my client has a problem with that. He says that he didn't do anything wrong and that he's willing to pay an attorney fee. An attorney fee would be associated with the case, but to penalize him with hours of community service where he believes that he did absolutely nothing wrong and was the target of abuse by the officer.
So Your Honor, I move for arraignment and I'll take pre-trial date then.
All right. Again, it's up to the DA. Do you need any more time to speak to the gentleman privately at all?
No.
You sure?
Okay, I'll pick
I
this
think the
up.
gentleman's raising his hand. I don't want to see this case drag on for the next 9 months.
Yeah, and I'd just like to have a word, if I can.
I'm going to let you speak to the, Ms. Curran. We're well into the lunch break here, to say the least.
If I can convey that. No, we can move for arraignment, Your Honor.
So I just told the judge we can move forward to arraignment because I was trying to converse with my public defender at the time, and I was trying to tell her that she needs to mention that my constitutional rights were violated, and she said that all she could. She said all that she could say. So I was asking her, well, let me convey it to the judge since you can't say that part. And instead of having friction back and forth in a session with my public defender, I just spoke up to the judge and said, we're moving forward to arraignment. So, and that concludes this audio recording right here. We can just hear the end of it and hear the continuous date and move on to the next video. Shout out to everybody in the chat. I appreciate y'all rocking out with me. It's the resistance. It's the resistance.
Fair enough.
Mr. John McCullough, docket number 1087. A non-guilty plea be entered on your behalf. What date, counsel?
December 18th, 12/18.
Again, sir, appreciate your patience today. I'll just speak to Attorney Karen, and maybe there's a meeting of the minds between now and that date, okay? And see what happens.
And the meeting of the minds was that I come to an agreement with the prosecution to accept community service, which I was not doing at all.
Mr. McCullough, you're being recognized personally for your next court appearance at the Dorchester Division of the Boston Municipal Court, December the 18th for a pretrial hearing. Any new court cases you pick up between now and your next court date, your bail can be revoked. You can be held without bail for 60 days.
Thank you, Your Honor. Thank you.
All right, thank you.
And according to their unconstitutional law, if I caught any more cases at that time, I was skating on thin ice, because if I did catch another case, if I just went out there and recorded a cop and the cop just said, you know what, or had knowledge that I had 2 prior arrests, because it's 3 arrests, you catch 3 arrests, then you get thrown in the can just for the fact that you're getting locked up frequently. But if there was an officer, and I was actively out there recording, y'all remember back in 2020, I wasn't stopping, but it was an officer that just wanted to throw his hands on me and put the cuffs on me, I'd be sitting for 6 months. A lot of things would have probably changed with the, the resistance movement and recording the police officers.
Why don't we take our lunch break, James?
All right, next up is the second pretrial hearing. This was on September 29th, 2021.
Court to dismiss the case.
All right, Attorney Granatino.
Thank you, Your Honor. Commonwealth is answering not ready for jury trial at this time. We are requesting a further date.
All right, Attorney.
Your Honor, I would object to a continuance. I would ask the court to dismiss the case.
All right. Understanding that there's some extenuating circumstances that came up today that Attorney Granatino wasn't aware of. Only objection. I'll give you one further date, one further continuance with Commonwealth. All right.
Would you just note in the docket that I objected?
Yeah, and that you were ready.
I would like to get if I could get a motion to dismiss and trial date, or that's fine.
Sure. What date?
I think we're into January. I could have January 18th.
That work for you, Mr. McCullough?
Give me 1 second, Your Honor.
Sure. Check out your calendar. The officers, check your calendar too, please.
Yeah. Things are backed up. There's nothing before.
January 18th.
18th. We have jurors on that day. Martin Luther King Day is the 17th.
Yes, the 7th.
So this was basically another continuance, me showing up for nothing, them playing the game, dragging it out, hoping that I would accept the community service.
17th is
Holiday.
is the holiday. It's also Muhammad Ali's birthday, and it's also
Muhammad Ali's.
It's also the day after. I'm squeezed between greatness. I don't know why I couldn't get any of it, but King was born on the 15th, Ali on the 17th. I was born on the 16th. Just a fun fact.
This is an unheard of administrator judge. Let me just highlight that real quick. He said he's squeezed between greatness. He says he's in between the birthdays of Martin Luther King and Muhammad Ali. And we're speaking of an administrator judge, okay, who basically just is in it for profit, collecting funds. If it's a body, it's dollar signs. If it's a ticket, it's dollar signs. And he's trying to put himself on top of the shoulders of Muhammad Ali and Martin Luther King. I'd be damned.
That's fine.
Sure. What date?
I think we're into January. I could have January 18th.
That work for you, Mr. McCullough?
Give me 1 second, Your Honor.
Sure. Check out your calendar. The officers, check your calendar too, please.
Yeah. Things are backed up. There's nothing before.
January 18th.
18th. We have jurors on that day. Martin Luther King Day is the 17th.
Yes, the 17th is
Holiday.
is the holiday. It's also Muhammad Ali's birthday, and it's also
Muhammad Ali's.
It's also the day after. I'm squeezed between greatness. I don't know why I couldn't get any of it, but King was born on the 15th, Ali on the 17th. I was born on the 16th. Just a fun fact. All right, we'll do the 18th. Yeah.
Motion to trial, motion to
Okay.
dismiss.
Motion and trial. Okay, we'll see you on that date. Thank you.
Thank you, Your Honor.
Thank you, gentlemen.
Thank you, Your Honor. Thank you, Madam Clerk.
Shout out to Jonathan Burks. So that was another pretrial hearing, basically a continuance. Mr. Bloody Wolf guy, Deanna Nace. That was basically another continuance. We can move on to the next pretrial audio hearing.
However, I will be candid with the court. We are still awaiting one officer, Scott Roby.
So this was actually the day of trial. The original date of trial was September 29th, 2021. And guess what? Scott Roby didn't show up. Scott Roby did not show up. So we all know that the trial date that I just won was scheduled for October 6th, 2022. It lasted for 2 days, the 6th and the 7th. And we all know at this date that I prevailed, I won, I beat the case. But the trial date was initially set for September 29th, 2021. And these are the games that Scott Roby played.
Which is what I think you requested, Mr. Hagemeyer, and I do the call for 1 year is what the Commonwealth requested. I think
Is that ready to go? We're ready to go.
It is the Commonwealth's on
Concurrent for Mr. McCulloch.
good morning.
Nicole Granatino for the Commonwealth.
Good morning, Attorney Granatino.
And Joan Karen for Mr. McCulloch.
Good morning, Attorney Curran, and good morning, Mr. McCullough. Good morning. Good morning, officer. All right.
This is a case that's on for jury trial today. It's the first date that it was on. I believe the Commonwealth is waiting for an officer still.
Attorney Granatino.
Thank you, Your Honor. Commonwealth is answering ready at this time. However, I will be candid with the court. We are still awaiting one officer, Scott Roby. It is the Commonwealth's understanding that he is currently on a detail. However, if this trial is selected to go forward today, Commonwealth is confident that we could get him here for the trial.
They're confident that they'll be able to get Scott Roby there before the trial, who never showed up all morning. Okay, look, so we got the audio right here. This is how this works. This is Massachusetts courts, jurisdiction Massachusetts courts, and this is FTR Court FM radio. I have to request this. I actually put an affidavit of indigency because my guy right here, Tyler Haskell, said, hopefully you get your payday because we all know you don't have a real fucking job. Well, anyway, my guy was actually on point at the time. So I put in an affidavit of indigency and they approved it. And once they approve it, you go online and you order it and you put in the times. You get the docket sheet from the courthouse, and you get your whole docket sheet from the case and you look through it, and anything that has a timestamp on it means that it was audio recorded, and you just fill that information in. But back to my original, what I was talking about is that it's almost 11:30 a.m. If you look at this dial right here, it's almost 11:30, about 11:25, and Scott Roby didn't show up yet. And these were the excuses that Granatino had made for Scott Roby for the day of trial.
Nicole Granatino for the Commonwealth.
Good morning, Attorney Granatino.
And Joan Karen for Mr. McCulloch.
Good morning, Attorney Curran, and good morning, Mr. McCullough. Good morning. Good morning, officer. All right.
This is a case that's on for jury trial today. It's the first date that it was on. I believe the Commonwealth is waiting for an officer still.
Attorney Granatino.
Thank you, Your Honor. Commonwealth is answering ready at this time. However, I will be candid with the court. We are still awaiting one officer, Scott Roby. It is the Commonwealth's understanding that he is currently on a detail. However, if this trial is selected to go forward today, Commonwealth is confident that we could get him here for the trial. He is a necessary witness.
I mean, we're here for trial, so you ready to go?
Yes, this is a case that Mr. McCulloch was, we're ready to go. We're ready to go.
Okay. Let's go. Get your officer here. Held for trial. Now, as soon as it gets sent out at 2, I'm expecting things to be ready to go. So unless it's going to be resolved, but held for trial.
So we was in session 2 in the beginning as soon as we got in the courthouse. And then we went to session 6. That's where this audio recording was held, in session 6. And it was ready for trial. And Scott Roby did not appear all morning. And then he appears I believe at 12:56, and I'm gonna have to fast forward that to get to 12:56.
Thank you.
That acts, I suppose, as some of them would be called, but also she's going to go to New York and
Okay, so that's another hearing right there. Now, what happened is that they didn't enter the timestamp for that audio because Scott Roby did show up. He showed up about an hour later. It was in between. See what time it is. So it was like around lunchtime. We didn't show back up, I think, until about 1:00. And he did show up, and the matter got continued. So we're gonna move on to the next one. You got a motion there?
I have a motion to dismiss. It says all four, but then in the body it says that there was no.
Basically my arguments for each basically my arguments for each charge. It is the four corners of the police report. If you're ready, I'll just go forward.
Yeah, please.
Okay. The police report submitted by Boston Police Officer Roby to the clerk magistrate alleged that on April 25th of 2020, he was conducting a traffic stop at Ansel Street and Blue Hill Ave. When he was returning to his cruiser, he states that the suspect, Mr. McCulloch, approached the vehicle that was the traffic stop that had two females inside and started recording them. And as officers told the suspect to step away out of the street, he walked up to the driver's side window and started asking the operator a question, was told to move away from the vehicle as they had turned their signal on and attempted to pull away. He states not wanting to talk to him, meaning Mr. McCulloch, and I believe that's in fear of the suspect, Mr. McCulloch. Officer believed he was told again to move out of the street and get on the sidewalk. They state that Mr. McCulloch, the suspect, refused the two verbal commands, and then the vehicle attempted to pull away, and the operator said, "Thank you," as the officer was walking back to his cruiser, and the suspect came back into the street and was told to get on the sidewalk a third time, at which time he refused and continued toward the officer's vehicle, not staying 6 feet away and being out after 9:00 p.m. The officer at that point went toward the suspect to place him under her arrest. And my point at this point, John, is that I suggest to the court that that's insufficient for a disorderly charge under the model jury instructions that I have attached to my motion. In order for a defendant to be found guilty of disorderly conduct, the following elements must be in place. And those elements are that the Commonwealth must prove that the defendant either engaged in fighting or threatening behavior, engaged in either violent or tumultuous behavior, or created a hazardous or physically offensive condition by an act that served no legitimate purpose for the defendant.
That was the whole argument right there. If you look in the video.
Go ahead. Yeah. Chapter 48, Section 98D, name the badge.
Step out of the street. Listen, I'm not going to tell you again, all right? Let me see your hands.
That's the whole argument right there. I never called a hazardous environment. I never, incited a group. I never obstructed any traffic in the street. This was this officer's ego. He was upset at what I was doing. He felt as though he needed to stop it, and that's exactly what he did. But I never did anything that rose to the level of a crime. That's definitely something I didn't do. And that's why I took it all the way to the end. And, you know, he looked foolish in the court. And remember, y'all, we got trial. I got the trial hearings coming up too, so stay tuned.
Also, that his actions were reasonably likely to affect the public. I believe that's the public at large, a group, not a specific individual. The Commonwealth must prove beyond a reasonable doubt, well, for this purposes, probable cause. There must be evidence that he intended to cause public inconvenience or annoyance. The police report is limited in what it says that he was reporting and went up to the police, went up to the women in the car and asked a question. He was asked to step out of the roadway and he refused to step out of the roadway. I suggest to the court that may be, as listed in the police report there, interfering with a police officer in the performance of his duties, or maybe failure to obey a police officer. That is questionable whether in fact that's what is occurring, but it's certainly not rising to the level of disorderly conduct requiring a situation where someone...
And I was upset that she even said that, because it wasn't even what she just said, what was crazy, or to even suggest that it was interfering with a police officer, because we know that interfering is physical. Supreme Court rule, interfering is physical. You have to actually physically get in between a police officer's duties for it to be interfering.
And asked a question. He was asked to step out of the roadway and he refused to step out of the roadway. I suggest to the court that may be, as listed in the police report there, interfering with a police officer in the performance of his duties, or maybe failure to obey a police officer.
See, I don't have to obey an officer's unlawful command, okay? I don't have to obey that. Now, I mean, eventually I did back up out the street because it was the time for me to be getting arrested. I was just documenting a traffic stop, and I had no time to be going through that on a Friday evening. I'm pretty sure most of y'all don't. But in my line of work, that's the hazardous conditions that I go through, okay? So it either comes whether I want it or not. So I got arrested that night. But to obey him, to say, hey, get out the street when I'm not obstructing any traffic, I'm not obstructing the flow of traffic, I'm not being violent towards anybody, and I'm not inciting others to get in the street with me, I tell him to go to hell, okay? So, you know, that wasn't enough for him. And when I did back up and step off the curb again, ask for his name and badge, that's when he flipped his top.
That is questionable whether in fact that's what is occurring, but it's certainly not rising to the level of disorderly conduct requiring a situation where someone acts in a fighting, threatening, or tumultuous, hazardous way in such a way to affect the public and to cause public inconvenience. So I suggest to the court that there's not sufficient evidence in the police report to support probable cause for a disorderly charge.
What about the fact that he walks up to two strangers in their car and is recording them and asking them questions in the middle of the street?
Listen to the judge. The judge is falling for the narrative. He's going for the bubblegum narrative. Listen to him. What about the guy walking up to the... He's falling for it. He's trying to push for this trial. That's basically what he's doing.
Disorderly conduct. Evidence in the police report to support probable cause for a disorderly charge.
What about the fact that he walks up to two strangers in their car and is recording them and asking them questions in the middle of the street? Couldn't that be considered offensive behavior, at least that served no legitimate purpose with regard to the two women that were in that car?
Well, I think that goes a little deeper as to what his question is and why he's there and what he's doing. And that's
right. He's not even, instead of asking me, instead of just mentioning the statement that I went up to the young ladies and just walked up to them, does it serve as no legitimate purpose? Why doesn't he question the fact of, why doesn't he question what I asked him? Okay. Why doesn't he question my legitimacy as well as he did the officer's legitimacy? Okay. Because I have a legitimacy out there as well.
not included in the police report. to just assume that that's offensive behavior.
Right.
I could go into exactly what Mr. McCulloch was doing on the sidewalk that evening, and that in the circumstances, his behavior was constitutionally protected. He, according to the police report, says the way the police officer phrases is that he was recording the women in the car. He was recording, and this isn't in the police report, I get that, because that's how the police officer phrased it. He was recording the whole interaction between the police officer and the women in the car. This was back in April of 2020, and he was just taking it upon his own, I guess, as a citizen to record the interaction between a police officer and an individual in the car, the women in the car, a traffic stop. And when the officer was finished with the motor vehicle, he approached the motor vehicle to ask a question. Now, the officer has stated that that rises to the level of disorderly conduct. I think that it does not under the statute, that there's no state sentence in here that we can point to that says what Mr. McCulloch was doing was threatening or fighting or tumultuous or hazardous, and that he had caused to affect the public inconvenience, annoyance, and alarm. According to the police report, he approached the two individuals in the car, asked a question. The officer puts in the police report that they did not want to talk to him and in fear of him. Those are conclusions that I don't think are supported by an observation. I mean,
he's a stranger walking up. There's no indication that he knew these two women, right? So he's a stranger walking up to these two women, recording them, talking.
This is a black bald head judge, right? What's his name? Let me look in the docket sheet. This is April 14, 2022. This is a black bald head moonshine judge. And, he's bootlicking right in the seat. He's just bootlicking right in the seat. And he's bootlicking the police officers because he's trying to back their narrative, which is crazy. April 14, 2022. Okay. 4/11, 4/14. This is Judge Keys. And oh my God, I just can't believe this is what made me upset. This was April, May, June, July, August, September, October, 6 months before the trial. And this was what really made me upset. And I was keeping tight-lipped about all of this, okay? Because I was taking it to trial regardless. But these right here, these were little tidbits and feeds that needed to be put together collectively, like I'm giving it to you now.
That I don't think are supported by an observation. I mean,
he's a stranger walking up. There's no indication that he knew these two women, right? So he's a stranger walking up to these two women, recording them, talking to them. They're trying to leave, from what I can gather from the police report.
What he gathers from the police report, he ain't even asked to look at the video. But that's what he gathers from the police report. Bootlicking all the way.
Observation. I
mean, he's a stranger walking up. There's no indication that he knew these two women, right? So he's a stranger walking up to these two women, recording them, talking to them. They're trying to leave, from what I can gather from the police report, and they're trying to pull away, and he's in the middle of the road. He says that he asked the operator a question, was told to move away from the vehicle, which I don't know if that was the officer telling him that or her, the woman who's the operator of the car. But I have to, looking at it in terms of probable cause, I mean, you can read it either way. It's either the woman saying, "Hey, no, get away from me, move away from my vehicle," as she's turning on the signal to her car and attempting to pull away.
Right, and I think that
and he's going strictly from the narrative of Officer Roby.
And in and of itself, it doesn't rise to the level of disorderly conduct under the statute. That may be, if it was fleshed out more, maybe it would be annoying behavior, maybe it would be accosting, but it's not disorderly conduct affecting the public. it's not tumultuous or physically offensive. The officer is finished with his interaction with the vehicle. He's going back to his cruiser or to his police motor vehicle. He sees Mr. McCulloch approach that vehicle, and he returns and tells him to get away from the vehicle. And that is the basis for, I believe, the disorderly charge.
Okay, all right.
Okay, and then the intimidation of a witness charge, the next charge. There's a question of who exactly the intimidation is. Is it the intimidation of the officer or the intimidation of the female in the motor vehicle? The officer puts in the police report, victim 2 was at Nayeli Maldonado. There's no information concerning this person, like an address, a phone number, a date of birth, but she's listed as a victim. I believe that in order to have an intimidation of a witness, juror, official, that there has to be some interaction between Mr. McCulloch and that person in a threatening manner, or an attempt to cause some kind of physical injury, emotional injury, economic injury, to harass, to intimidate, and that person has to be a witness or a potential witness, that they're involved somehow in some kind of court proceeding. I mean, arguably, stating that somehow Mr. McCulloch is doing something to interfere with the citation process. It doesn't necessarily make sense to me that there's nothing that appears from this that is influential in a negative way in the citation, I guess the citation process. There's no allegation. I mean, the police officer puts in his report, he uses the word far, and in far of the suspect. I assume that he's trying to say that the person in the car was in fear of the suspect. However, again, there's no support as to whether she's making any kind of claim that there's any kind of apprehension or any kind of concern with Mr. McCulloch approaching the motor vehicle.
But what is she witness to? What is she witness to? Like she's potentially a party in a litigation, right? But she's not necessarily a witness.
Right.
Right. I guess that's more of a question that I would have for 88 Granatino.
So how is she not necessarily a witness? Like, she's seen the whole beginning of me coming up to record. She's a witness to me recording because I was standing right in front of her. You see how they try to flip it?
And in the police report itself, it appears that the officer isn't seeking any kind of intimidation of a witness charge. However, the application of the complaint includes that charge rather than the charge that's asked for in the police report, which is interfering with police officer in the performance of his duties. I don't think there's actually a criminal charge for that when someone isn't in a motor vehicle. I don't think, I see it comparable to not obeying the commands of a police officer, but that only affects when someone's in a motor vehicle. I don't see in this fact pattern intimidating a witness, a juror, a court official, or law enforcement officer by the behavior of Mr. McCulloch by going up to the car after the officer is going back to his cruiser through with the traffic violation interaction and asking a question, that's intimidating the officer. And I don't believe that there's enough support in the police report to show any kind of intimidation of the individuals in the motor vehicle. Then as to the resisting arrest charge, the officer states that at this point, when he refused to get back on the sidewalk, the officer went towards the suspect and placed him under arrest. At that time, he was told to put his hands behind his back and he was going to be placed under arrest. And he resisted by pulling away from officer. I believe for a resisting arrest charge, that pulling away from an officer isn't sufficient for resisting arrest, that a person who commits a crime of resisting arrest by either using force, physical force, or threatening to use physical force or violence against a police officer, or by using any other means which creates a substantial risk of causing bodily injury to the police officer. From the police report, it doesn't state that Mr. McCullough put the police officer in any kind of substantial risk position. I always think that that's a situation where you run into traffic and the officer is in a position where he's now in a substantial risk of hurting himself. But it appears that it's not specifically stated, but that Mr. McCullough stood there and pulled away from the officer. And then the officer goes on to state that, and grabbing my left hand and scratching my finger with his fingernail. As he did so, officer's spray was released or discharged next to the officer's hand and arm. So I suggest to court that is the basis that the Commonwealth is putting forward for the assault and battery on the police officer, that they're two separate things, that Mr. McCullough resisted by pulling away from the officer, and that's the resisting arrest, and that the grabbing my left hand and scratching my finger with his fingernail is the assault and battery on the police officer.
All of this is being done in the middle of the road, Blue Hill Avenue.
So to be clear, ladies and gentlemen, these are all pretrial hearings that you're listening to, and this exact hearing is to dismiss charges. We're here today on the 14th of April, 2022, which was months ago. We were there that day to dismiss charges. Now, the charge that did get dismissed was the intimidation. Okay, so we were trying to get everything dismissed, but we got the bootlicking judge who's sitting in front of us going for the bubblegum narrative of Scott Roby.
We're near Ansel Street and Blue Hill Avenue, at least that's how I read this. So he's in the middle of the road because the vehicles tried to pull away.
Listen to what he's saying. And this is like I called it, the bubblegum narrative of Scott Roby and the police officers of B3, okay? They made it seem as though I started a whole hazard in the road, in the middle of the road. It made it seem like that it started that way. Because if you see Scott Roby's video, if we were to just rely on Scott Roby's video, because they were trying to get my video up out of there. They were trying to motion to get my video out of there. Exculpatory evidence. They put that motion in there. It's in this docket sheet right here. They were trying to get that out of there. If we would have just had to rely on Scott Roby's narrative, it would have shown me in the middle of the street. Okay, it would have shown me first in the corner, then walking up to the middle of the street. So it would have been maybe a little harder to try to beat that charge than it would have been. It was easier to beat it with my footage as well, because it showed I was peaceful. I was a concerned citizen. I was just out there recording an officer during the course of his duties.
They're trying to place him under arrest in the middle of the road, and in the process of doing that, he pulls away and scratches the officer's finger. So the officers place them, so the officers are in, at least as how I read it, the officer has to place themselves in some kind of danger by going into the middle of Blue Hill Avenue, which we know is a major public thoroughfare.
Wow. Once again, a black judge. This is Dorchester Court. This is in Boston, Massachusetts. A black judge bootlicking all the way in the courtroom.
Injured as he is pulled, the hand is pulled away from him and he's scratched on his finger. As he refused to get to the sidewalk in that third paragraph from the narrative. So the officer had to go out into the middle of the street to place him under arrest, and then he's refusing in the middle of the street, keeping the officers in this middle of this roadway.
You can read it that way, that's for sure. You
right,
can.
yeah. And his story might be different, You might have a different version of it, but as I read that police report,
This put in front of a clerk magistrate, he does not put him either in the street or on the sidewalk, but based upon the fact that he writes the statement that he was told to get on the sidewalk, he does not specifically note in his police report where he effectuated the arrest.
right.
But again, as to use of force or use of physical force, I will say that is not suggested in the police report, and the police did not specifically write in their report that the arrest occurred in the middle of oncoming traffic. So to assume that or to say that you can't be sure one way or the other, I would suggest that the benefit inures to the defendant rather than the police officer for leaving things out of the police report that would support the element that the officer was putting himself in a hazardous situation. That is not clear from the police report. And as to the assault and battery, grabbing my left hand and scratching my finger with his finger, I suggest that that's not an intentional use of force on the officer. It says under the assault and battery for an officer, it says that the defendant touched the person, intended to touch the person, and the touching was either likely to cause bodily harm or was offensive. I suggest to the court it's not clear here, but that Mr. McCulloch was sprayed at the same time, and that it's not clear that it was inadvertent, any scratch to the officer. And the officer doesn't reflect that he submitted any kind of proof of injury in the police report, other than stating that his finger was scratched. So I know I have difficulty a little bit more on the assault and battery police officer where he says his hand was grabbed, but leading up to the disorderly, the intimidation of the witness and the resisting arrest of pulling away from the officer, I suggest that all three of those do not meet the criteria or the specific elements, that there's evidence of specific elements of those charges to render the basis or enough probable cause to issue the complaint.
Okay. Just a note in on the second page of the narrative, the officer writes that Mr. McCulloch grabbed the cell phone out of his hand and pulling it into the car with him. Could that amount to assault and battery on a police officer, do you think? At least give the clerk magistrate probable cause, a reason to believe that the offense, that there was an assault and battery, where the officer's holding the cell phone and he has to reach out and grab it from him.
Well, under the assault and battery on a police officer, it's the third element. It said the touching was either likely to cause bodily harm to the officer or was offensive. I think the process of giving him back his phone and grabbing it from his hand doesn't rise to the level of the possibility of causing bodily harm or being offensive in the situation.
Well, would they be giving him his cell phone while they're putting him away in the wagon? Would they be giving him property?
In this particular case, they were.
Okay, this I give, there's some sloppy writing here, but yeah. Okay, thank you. Ada Granatino.
Thank you, Your Honor. Nicole Granatino again for the Commonwealth. Your Honor, the Commonwealth asks that you deny my sister's motion to dismiss on all four counts: disorderly, ABPO, witness intimidation, and resisting arrest under Commonwealth v. Benedetto. Your Honor, looking at the police report and arguing this within the four corners of the police report, Your Honor, I first would turn to disorderly conduct. Your Honor, the Commonwealth would argue that there is probable cause to support charge of disorderly conduct before us today. In order to prove disorderly conduct, one must show that an individual is involved in a hazardous condition with no legitimate purpose, that it affected the public and that there was a public inconvenience or alarm. And I would suggest, Your Honor, that there was in the case before us, in the fact pattern before us today. I would suggest, Your Honor, that the defendant clearly was involving himself in a situation, placing himself in a situation which he did not need to be involved in. The officer was conducting a motor vehicle stop. Candidly, I don't even know what that motor vehicle stop was. I just know that.
So let me just stop real quick. They're saying that I'm involving myself in a situation that I had no business involving myself in. What I was doing was protected by the Constitution under the First Amendment. And I made sure that the officer was done with the stop before I even walked up to the car. I seen the officer hand the documents over. Okay. I seen the officer walk to his car, and I even asked him, was he done with the stop? And he ignored me. So I made the conscious decision to proceed to the car and ask the driver a question, which was harmless. Everything that happened after that was the officer's actions towards me. Okay. It was an unlawful arrest, and that's why I beat the case.
He pulled over a motor vehicle with two women sitting inside, and that the defendant then came over and began filming. For whatever reason, I don't know why he was filming, but there was filming. And I would suggest, Your Honor, that those two women were women in public. They were on a public way, Blue Hill Avenue in Dorchester. And I would suggest that that behavior was a public inconvenience, Your Honor. And I would suggest that there is probable cause to support the charge of disorderly conduct. And I would.
So walking up to somebody and asking them a question is causing a public disturbance. It's a public inconvenience.
Just, and I apologize, I don't know the exact facts of the case, but Commonwealth v. Vosk, which is highlighted in the jury instructions for disorderly conduct, is a 1990 case where it says a motorist who stood in traffic lane forcing vehicles to pass around them while debating with a police officer and refusing to return to his car was enough to support disorderly conduct. And I would suggest, Your Honor, that the facts in this case, while it was not necessarily disclosed as a busy street, there still were cars. It was 1:20 in the morning, Your Honor, but Blue Hill Avenue, I think we can assume that there probably were other cars in addition to the two women in the stop motor vehicle. And I would, again, just highlight, I do believe that there is probable cause to support the charge of disorderly conduct.
So I just want to try and understand this. You're saying the mere fact that he was videotaping these women that he didn't know on a public way amounts to disorderly conduct?
And my apologies, and to clarify, and after an officer instructing him to stop, to remove himself from the situation, I would suggest amounts to disorderly conduct. He was.
So she's saying that the mere fact of me recording, which we all know is not anything that constitutes disorderly conduct. She tried to say because the officer told me to stop is the reason why I should be charged with disorderly conduct. After the officer told me to stop filming and to get out the street is why I should be charged with disorderly conduct.
Way.
In addition to the two women in the stop motor vehicle. And I would, again, just highlight, I do believe that there is probable cause to support the charge of disorderly conduct.
So I just want to try and understand this. You're saying the mere fact that he was videotaping these women that he didn't know on a public way amounts to disorderly conduct?
And my apologies, and to clarify, and after an officer instructing him to stop, to remove himself from the situation, I would suggest amounts to disorderly conduct. He was advised to get off the street, get out of the middle of the road, stop filming. And
so it's the fact that he's in the middle of the road that's another factor that you're taking into consideration. So you're not just saying the mere fact that he was videotaping amounts to disorderly.
No.
Because that's what I was assuming. That's what it sounded like you were saying to me.
My apologies, Your Honor, and thank you for allowing me to clarify. It would be the fact that he was in the public way, not removing himself from the situation when asked by officers asking him to get out of that public way, a busy street in the city of Dorchester, as we all know. I would suggest that amounts to disorderly conduct, Your Honor. Right. Turning to the witness intimidation charge, Your Honor, I would again suggest there is probable cause to support the charge of a witness intimidation here. Your Honor, I would suggest that the defendant in this case, looking at the jury instructions, willfully harassed a witness or potential witness with the intent to obstruct a civil proceeding. And I would suggest here that that civil proceeding being the car stop, Your Honor. I would suggest, Your Honor, that going up to two strangers who a defendant doesn't know, attempting to film them, not listening to officers as they asked them to move after they attempted to complete the motor vehicle stop. The officer was walking back to his car. The defendant then coming over with his camera, filming them as they were attempting to leave. I believe in the police report it even says.
So the officers had already completed their job.
The officers had not even gotten back into their vehicle, though they were about in the process of completing their job. Yes.
Well, the people in the car were leaving, right?
Attempting to leave, yes.
Right.
And
so the interaction between the officer and the people in the car was done. There's
is
nothing
correct.
more that the officer. So the interaction doesn't end when the officer gets in his or her car. The interaction ends when the officer's done with whatever he or she's doing with the people in the other car, right?
That is correct, Your Honor. But as the officer realized that an individual was approaching, these two women were unable to leave from their stop, their traffic infraction that they were being pulled over for, whatever that was, which we don't know. He made note that that vehicle could not leave, and that's when he asked them to leave. And so I would suggest, Your Honor, that is harassing or annoying in some way. And in the jury instructions, it does clarify what harassment means. And it does say to annoy a group or person, causing them to suffer from some sort of distress, Your Honor. And I would suggest here, although the police report might not necessarily say that the two women in the motor vehicle were distressed, I would suggest, Your Honor, that a stranger coming over to your motor vehicle while holding a video camera to you is likely a situation that would put someone in a distressful situation.
Wow. It will likely put someone in a distressful situation. Most people, yeah. And even if it does put them in a distressful situation, the other party who's holding the camera is protected under the Constitution.
Especially not knowing them or why they're coming over to them and filming them in the first place, Your Honor.
But they're not witnesses in the true sense of the word, right? They are participants in a traffic stop and potential parties to a potential civil hearing that has not yet been established yet, right?
Right, and I would suggest, Your Honor, though, that they were a witness to this disorderly conduct, and that's kind of the Commonwealth's position here.
But it's his potential disorderly conduct that gives rise to this case, right? They were not yet witnesses at that time that he was doing it. It was his actions that led to the disorderly conduct charge, right?
Correct, Your Honor.
So it's not as if that they were witnesses prior to his interaction with them to a disorderly conduct case, because there was no disorderly conduct charge.
So what the judge is trying to do is actually exclude the driver and the participants in the car as witnesses, because everything pretty much happened after she pulled off. So he's just trying to get down to the nitty-gritty as if they should be a part of this case.
At that point, correct, Your Honor, and I guess I would just highlight witness or potential witness is the language that the jury instructions use, and I would just consider those two women potential witnesses to the disorderly conduct that was occurring during that interaction, as officers were telling.
Shout out to Mark Wunderlich. She says, did she say your lawyer is her sister? Yes, she did in the beginning. They refer to each other, prosecution and public defenders, defense lawyers, they refer to each other as their brother and their sister.
The defendant to leave the scene.
Okay.
Turning to the charge of assault and battery on a police officer, Your Honor. Again, I think my sister highlighted most of the facts, but I would just suggest that the defendant did touch police officer, Officer Roby, by both grabbing his arm as well as by grabbing at the police officer's hand, attempting to pull his phone out of his hand. I would also suggest, Your Honor, that he did in fact intend to touch. That was an accidental contact. He wasn't accidentally grabbing at the officer's hand or grabbing for his phone out of the officer's hand on either occasion. I would also suggest that that is offensive contact, Your Honor. Officer Roby was clearly trying to effectuate a traffic stop. He was wearing a full uniform as described in the police report. He was outside of his cruiser. I think it's clear that the defendant knew he was engaged in his duties as a police officer and knew he was a police officer at that time. So I would suggest that there is probable cause to support all 7 elements.
I'm trying to understand that. How do you pull away from somebody and then grab them? Like if he's trying to resist arrest, like the resisting arrest and the assault and battery charges seem to kind of contradict each other. If he's trying to get away from the officer, why is he trying to grab him? Right? Doesn't it make more sense that he's pulling his arm away from the officer and in the process of doing that, he accidentally hits the officer? I mean, the officer's trying to put him under arrest. He's saying, leave me alone.
Right.
Why is he trying to grab an officer if he's trying to not be arrested by the officer? That's kind of counterintuitive.
I hear you, Your Honor. And in the police report, it does say he was resisting by pulling away, kind of grabbing in his hands. Based on my reading of the police report, perhaps he could have just been using his hands in any motion to attempt to get away. I would agree with you. It kind of is unclear, but what is clear is that there was contact that was made, and that was unwarranted contact while he was working. Whether or not it was more of a pull or a push, I think that it's clear in the police report. He, in fact, grabbed my left hand, scratching my finger with his fingernails. And again, later on in that paragraph 3, the officer does highlight again that he was grabbing a phone in a second incident out of his hand. So I think that that could go to either of those incidents, Your Honor. And then lastly, turning to the charge of resisting arrest, I would again state that there is probable cause to support the charge of resisting arrest within the 4 corners of the police report, Your Honor. If I may just have 1 minute. My apologies, Your Honor. I was just clarifying. In order to support this charge, Commonwealth must show that the defendant prevented or attempted to prevent a police officer from making an arrest. I think that's clear here, Your Honor. The defendant himself was attempting to prevent the police officer from arresting him after his disorderly conduct. Secondly, Your Honor, Commonwealth must show that that officer was on duty working. Again, he was in his uniform. The defendant witnessed him pull over a vehicle, acting in his lawful authority as a police officer before this incident between the 2 of them occurred. The defendant did, in fact, pull away. He resisted arrest, as highlighted in the police report, grabbing his left hand, scratching my finger with his finger. And lastly, again, the defendant knew that he was a police officer and knew the defendant did so knowingly. That is to say that he knew at the time that the police officer was working. And again, I would just highlight wearing a uniform. He watched him make a traffic stop. And therefore, for all these reasons, Your Honor, the Commonwealth would suggest that there is probable cause within the 4 corners of the police report to support all 4 charges that are before Your Honor today. And I would ask that you deny my sister's motion to dismiss under Commonwealth v. Benedetto.
Okay. I'm allowing the motion as to count 3, the intimidation of a witness charge, denied it as to counts 1, 2, and 4. I think count.
So that's when he did. That's when he denied the charge of. That's when he allowed the charge of intimidation to be dismissed, and he allowed the other charges to go through.
2's a close call, but there's
Shadow.
okay. I'm allowing the motion as to count 3, the intimidation of a witness charge, denied it as to counts 1, 2, and 4. I think count 2's a close call, but there's something in the police report I think that does support it, so I'm going to deny it as to count. That's the assault and battery on a police officer. So I'm denying.
He said count 2, assault and battery on a police officer is a close call. He wouldn't dismiss that.
It has to count 2, 1, 2, and 4.
Thank you, Your Honor.
On the sidewalk,
Regarding, your motion to dismiss regarding the video?
I do. I have a motion to dismiss Commonwealth versus Odell. In this particular case, Mr. McCulloch was on the sidewalk. He had a system, not only his own personal phone, but it was hooked up to something that he could put on a handle and film. And he was out that evening filming different areas of the city when he came across the officer in a motor vehicle traffic stop on Blue Hill Ave. And he filmed the interaction between the officer and the individuals when the car was pulled over. And then when the car went to leave, when the officers were through, he approached the car and he was videoing. The officers also have their body-worn camera on. There was 2 officers in the marked police car, and each of those officers had their body-worn camera on. I have Mr. McCulloch participates in a YouTube series, and he posts these videos on YouTube. So I have a copy of the video that he has, and that video reflects that Mr. McCulloch was on the sidewalk and did respond to the police request that he go back to the sidewalk. The request by the police were rapid. They weren't giving him time to go back to the sidewalk. The state started yelling at him after the motor vehicle stop to get away from the car. Police officer approached the car, asked the car to leave, and told the car that it could leave, and continued to ask Mr. McCulloch to stay on the sidewalk. Mr. McCulloch asked for their badge numbers, and at that point, the police officer approached him and said, I'm not putting up with this anymore, I'm arresting you. And it's on video. The disorderly portion clearly, and from the perspective of the officer's body-worn camera and the perspective of Mr. McCulloch's video, I believe you can see that he is not resisting arrest. The assault and battery police officer charge, that is something that is hard to tell, I think, because the police officers at that point have their hands on Mr. McCulloch and are making the arrest. And when the arrest is already in place, Mr. McCulloch is screaming that he's been sprayed with something. And it says in the police report that the officer had his OC spray in his hand and it was discharged at that point. And I suggest to the court that observing this video that was available to the police at the time of the clerk magistrate's hearing, and that they had Mr. McCulloch's phone so that they could secure the video that he had taken, was available to them to present to the clerk magistrate, and that they failed to do that. And I think that the evidence is so exculpatory that it rises to the level of a dismissal of the charges if viewed by the court. That certainly the disorderly charge and the resisting arrest charge, and I would suggest also that the assault and battery charge should never have issued based upon that evidence. So I would ask the court to consider taking the videos. I have the YouTube video, and I think between myself and the Commonwealth, we could submit the body-worn camera video and ask the court to look at that and consider whether that evidence is such a nature that it should be considered in whether this case the complaint should have issued.
Was there any obligation of the police obligated to present the video to the clerk magistrate for
Well, I think-
seeking the complaint?
Well, I think the idea is when they know that the video contradicts the police report, I think there is an obligation because there's clearly exculpatory materials or evidence in that video that showed that Mr. McCulloch is on the sidewalk when it asked, to stay on the sidewalk, that he's asked for his badge number, and that is when the police officer states, "I'm going to arrest you. I'm not putting up with this anymore." And that you can see in the video that Mr. McCulloch's arms are straight down, and that in one hand he has the phone, and in the other hand it's obvious his hand is straight away, and they're taking the handcuffs and putting him in handcuffs, and at that point he's in handcuffs, he's arrested, he can no longer be charged with resisting arrest, and he's saying, "I've been sprayed." So at that point, I believe that you would be left with the determination that there's not probable cause for an assault and battery, given the view of that incident. Mr. McCulloch is screaming for his phone because he was concerned that the video would be destroyed in his phone. And that is comes out in the video as to why the police, I think at that point, gave him back his phone. He keeps yelling, "I want my phone, I want my phone." The court was interested in why they would be giving him property because he was so concerned about his phone. But I think in the video you can hear noise where the police are stepping on the phone, and that the phone appears to be destroyed. But in effect, because I guess of the streaming nature of the video, he was able to save it. Although I have a picture of the phone was actually destroyed.
Why, if this happened on April 25th, what happened how come and he was arrested? Why wasn't he arraigned until May 13th? And why didn't the complaint issue until May 27th? Let me see a calendar up here.
I believe it was because of the COVID pandemic, Your Honor, based on the Commonwealth's file.
Oh, it's just 2020. I see. I got it. All right. I'm thinking it was this year. All right.
It was, and that's part of what, Mr. McCulloch out there filming. I think it was also, at the beginning of the pandemic when there was a lot of issues with the Black Lives community, that he decided that he was going to go out and be somebody who reported interactions between police and civilians, seeking to have police accountability in the community. I can submit the video and just ask the court if it would consider maybe taking it under advisement. I get the other video to you, if you think it's of that nature.
Well, I mean, isn't that really a decision ultimately for the fact finder to determine what's in the video, as opposed to me doing it in a motion to dismiss? I mean, shouldn't that be for?
I think this is the first time I've ever done one of these, to be honest with you. On an Odell motion, as we go along doing these cases, as a defense counsel, and I think also as a prosecutor, is we're seeing more and more video. And the video is having an effect on how we present our cases, and saying, is this really a case that necessarily has to go to trial when the video is so clear?
And is this body cam video, or is this Mr. McCulloch's video?
It could be both. All I have right now on a CD is Mr. McCulloch's YouTube video from his direction, but could also submit the body worn camera video.
So how will the police department, how will the police officers supposed to have that video?
They had
to
his phone.
present?
I mean, they arrested him.
Do they have access to the video on his phone? I mean, our phones are protected in so many ways, and there are passwords and biometrics that are needed to kind of get into a phone. How is it that these officers And if they went into his phone, I mean, they can't even search his phone without a search warrant, right? They didn't have a right to go into his phone without a warrant. So how could they have gotten the video in time for the clerk magistrate hearing, which was?
Well, I don't know if Odell is limited to the issuance of the complaint, or if Odell is something that I could bring up during the pendency of the case to show that there's exculpatory evidence that should be considered by the court.
But Odell was just, it was his presentation to the grand jury, right? Was it, and the officers or the Commonwealth had knowledge and access to exculpatory evidence. In this instance, do they really have access to this video that you want me to look at? Because
well, I guess their body camera would be the same. It'd just be.
Well, do you have the body camera video? And what does the body camera video show?
The body camera video shows Mr. McCulloch on the sidewalk. It shows Mr. McCulloch approaching the motor vehicle and how he is on the street. It shows whether there's traffic in the area. It shows that the stop is over and that there's no interaction with the individuals in the car afterwards to consider whether they were in fear or if they didn't want Mr. McCulloch approaching, those types of things.
All right. I'm not set on taking the video just yet. I want to hear from Maggie Granatino.
Thank you, Your Honor. Nicole Granatino again for the Commonwealth.
All right, and we're going to conclude right there and continue. I'll continue later on tonight with that. You guys make sure y'all hit the notification bell, because I'm being kind of like hidden in the gallows of YouTube. So if you guys want to, unsubscribe and subscribe again, just to, be refreshed with the Resistance channel, that'll be much appreciated. Once again, ladies and gentlemen, I got all the audio hearings. We're in pretrial hearing right now. I played a good portion of that. It's been about 2.5 hours that we've been listening to pretrial audio hearings. We're going to continue with this hearing that we were listening to. We're wrapping it up, and then at a later date, we'll start with the trial. Sounds good? Y'all let me know. Appreciate y'all rocking out with me. I want to give a shout out to all y'all. Y'all make sure y'all hit that notification bell. First, unsubscribe and then subscribe. It's unsubscribe and subscribe. Then hit the notification bell so you can get an idea of when I want to play the next segment of this pretrial hearing that we were just listening to. Okay, and then I'll put up the dates or give you some notifications of when I play the audio for trial. But shout outs to Look Resistor UK, Deanna Nace, Ann and Mouse, John Denicola, Tarif L. Hey, I beat the case, bro. Just in case you didn't know, I beat the case, not guilty. Perfect Sense is free to stay. Rhonda, Woody Ting UK, appreciate y'all. Mark Wunderlich, Mr. Bloody Wolf Guy, Nico Argotti, appreciate y'all. The gang is all here. Wolfie Gladly, the Cop Vader, Young, Facebook user, Scrubzilla, Daniel Garcia, Breaking the Floor, Wake Up, Lion One. Like I said, y'all make sure y'all hit that like, subscribe, share, hit the notification bell. I'll be coming with y'all with the rest of this pre-trial hearing a little bit later on tonight. If I don't do it tonight, you will get a notification of the next time I'll be playing it, which will be most likely tomorrow. But I'm going to make it for tonight, Halloween night.
Hit the likes. Everybody about to get killed out here. Like it for